Frank Molnar invented and patented a two-post car hoist, the sort of hoist that a mechanic might use to lift a car up to work on it. His company, Molnar Hoists, which is still in operation today, sold these hoists in Australia and overseas. E.J. Burns was the Chief Inspector of Lifts and Cranes in Victoria's Department of Labour and Industry. He formed the view that the hoists were unsafe and took the unusual step of placing an ad in the newspaper to advise people the hoists were unsafe and should not be used. Sales, unsurprisingly, plummeted. The company sued on the basis that Burns' statement was misleading and deceptive conduct under the Trade Practices Act. Burns, with the resources of the state behind him, defended the action and proposed a very long trial at which he would call 20 witnesses. The costs skyrocketed, and it became clear to Molnar that the company, already in financial trouble due to the loss of sales, couldn't afford the trial. Molnar applied to be allowed to represent the company personally. Now, in another case which we've covered on this channel, Hubbard, Scientology and Anderson, the court found that a company has no right to appear in person through an agent, but the court can still grant leave for a person to do so, and that was the application here. So it wasn't suggested that Molnar had a right to appear, he was just seeking permission. The difficulty, though, is that a litigant in court is not just there to fight their case. Their first responsibility is to assist the judge to do justice. The judge had to consider whether Mr. Molnar would be capable, without training, of running a complex trial. The judge said, "I have much sympathy for the position of the applicant in this case. Much weight must be given to a litigant, being a company, to be able to present its case before the court. But having regard to the nature of these proceedings and the difficult questions of fact and law which arise, this is a case which, in my opinion, the court should have the benefit of legal practitioners appearing for the applicant." Something stinks about this case. The idea that Burns used the resources of the state to bludgeon Molnar out of court doesn't sit well with me, but the judge's decision ultimately seems reasonable.